Okay, good morning. Welcome to today's Ask a Pro webinar. Today's topic is Secrets of the Subrogation Attorney Part 2 or Part 2. My name is Ted Traut. I will be the moderator for today's session. I'm the Subrogation Group Chair. I'm a shareholder and I'm the Office Managing Attorney for the Cleveland office. So I sit in Cleveland, Ohio. In my role, I practice subrogation and I handle subrogation claims in the state of Ohio. I also back up our national litigation network and our collection group, so sort of act as in-house counsel for those folks. I've practiced subrogation for my entire career, which goes back to the year 2000. It's sounding longer and longer ago the further we go. But without any further ado, I think most of you have heard from me before, so I'm not going to sit here and give my full biography. Let's hear a little bit about more of our panel because we got some really good attorneys here willing to share some knowledge with you today. So let's hear about Mike Chapman. Mike, if you could introduce yourself.
Yes, I'm originally an Indiana guy, go Hoosiers. I'm primarily practicing subrogation in Kentucky and Indiana, and I also do a little bit in Ohio, and I've been doing insurance defense work, I don't know, for about 20 years. And I recently switched over to the subrogation side. I did a little bit of subrogation work prior to that, and I'm really enjoying it. Thank you.
All right, and I already made my first error. I forgot to advance the slide, right? It's hard to multitask, just not great at it. So let's go ahead and let's hear from Nathan a little bit.
Sure, thanks, Ted. Nathan Duvelius, I'm one of the attorneys in our Cincinnati office along with Mike. I primarily practice in Indiana on the collection side, doing credit cards and student loan collection stuff. I do a little bit on the foreclosure side with our real estate default group in Indiana and Kentucky. And then I kind of help out Mike a little bit on the subro stuff for Indiana every once in a while. However, I think one of the primary reasons I'm on this panel today is prior to my role at Weltman, I worked for a debt buyer where I was kind of in-house counsel and kind of a traveling witness. So I've been on the stand, I've been deposed a couple of times. So that's kind of why I'm here and why I'm talking to you guys today. So I've got a little bit of a unique perspective on the witness preparation side. On both sides of the witness box, so to speak. So hopefully we'll get a chance to share some stuff about that, and glad to be here.
Thanks for being here, Nathan. Tiffany, let's hear from you.
Hello, everyone. I'm Tiffani Williams Palmer, actually now, and just got married less than a month ago. So I'm a subrogation attorney in the state of Michigan. So I handle exclusive subrogation files, primarily Michigan files or some sort of connection to Michigan. Now I have an interesting background, and I used to actually be a claims adjuster. And then after I worked as a claims adjuster, I went to law school, and then I became a plaintiff's attorney. So I started suing insurance companies. So I always poke fun at some of my clients and let them know that I used to sue you. Now I'm on the good side. So that's a little bit of background about me. I also assist Ted in overseeing some of the general operations of subrogation throughout the entire firm.
Great. Now just a couple of housekeeping items before we get started. We're hoping for this to be an interactive session. If you folks have any questions that pop into your head while you're listening, please go to the little panel and type in the chat your question, and we'll be happy to address that when we can get to it. Also, the webinar is being recorded, so if you've registered, a link to the recording will be sent to you after we conclude the webinar. Also, at the end, we will send you a brief survey. And it's really helpful if you could share your feedback, what's good, what's not, what would you like to hear in the future, because that really helps us with our programming. This is all for your benefit. So anything you think of that you want more information on, feel free to share with us. Our goal is to get this done in an hour or less. We'll see if we can get these attorneys to not blather on so much that we can get that under an hour, but we'll see. but that's the goal. Otherwise, we'll go ahead and get started. Again, this is an Ask a Pro series, so we're looking at questions that are coming from our clients typically, or been registrants have sent in. So the first question, I think it's probably the billion-dollar question, right? How do you decide whether to go to trial or to accept a settlement offer, and what things do you analyze when looking at that? So let's start off. We'll go to Tiffani first, and Tiffani, if you want to join in on that.
So what I tell my clients is you want to know, what do you want, what is it worth, and what's the likelihood of collection or success. So when you're looking at whether to settle a case or go on to trial, you obviously have to understand the strengths and the weaknesses of your case. And sometimes understanding the strengths is really, really easy, and recognizing the weaknesses is a little bit harder. So you talk to your attorney, get counsel from your your attorney regarding what do they perceive are the weaknesses of the case. Then you want to also analyze things that you don't normally think about. So for example, you want to analyze the cost of actually having a representative come and testify at trial. You know, what cost is that to the business? Because when you're talking about subrogation, the purpose of it is to recover money for your company. You know, so you have to look at it holistically, not just necessarily what are the fees, because the fees may be nominal to file a case, and maybe even to go to trial if you don't have any witnesses. But there's also time capital that's involved as well to the company. And then there's also a cost in bringing the actual case to litigation in front of a jury. So remember, it's typically on one side of the V, it's the insurance company. On the other side of the V, it may be a layperson's name at the very least. So you want to look at those things and put that into consideration as well, because the jury is comprised of potential consumers, potential clients of yours, potential customers of yours, that you want to show that you're fair and that you're working for your insureds, but also that you're not trying to beat up on, the little guy. So you want to weigh those things as well. When you're looking at whether to settle a case, like I said, make sure you have a understanding of, if I'm sticking to this number, am I sticking to this number because this is the best number the case should settle for, or is a little bit of my own personal motives getting in? Am I sticking to that number because I just want to stick to my guns and I just feel like that's right? Unfortunately, this is not a feelings game. This is all about the bottom line, the numbers that come back to us. So we want to make sure that when we're settling the case, it is for the best reason possible. It is the best decision for the company.
Mike, anything to add to that in your experience?
Well, when I get ready for a trial, I get way too invested in the case, and I go into full advocacy mode. And at that point, I want to win and I want to get 100%. And I sometimes need to take a step back and reflect on, some potentially bad outcomes. Whenever you go to trial, risky things happen, and sometimes it's unpredictable. You never know when an insured's not going to show up. And even when they do show up, sometimes their stories change. And sometimes, witnesses don't show up, and sometimes their stories change. And other times you can have a great case, and no matter what you do, the judge or jury just does something completely wrong, and you get an adverse decision. And sometimes you get lucky and win, and it's highly unpredictable. So if there's ever an opportunity to do a consent judgment on a payment plan for the full balance against the pro se defendant, that's almost always preferable to go into trial, because if the pro se defendant defaults on the payment plan, then you've got the easy judgment, nothing to worry about. If there's an insurance company on the other side, you're going to be up for some surprises. And no matter how well you think you're prepared and how good you can present your case, when you're up against litigation defense counsel, strange things happen, and it's often very unpredictable. So, when you step back and you think about, is this really worth going to trial? Usually it's not.
Yeah, it sort of reminds me.
I still like doing.
I'm sorry. Yeah, it reminds me of the Mike Tyson quote, right? Everybody's got a plan until they get hit in the face. And particularly when you've got defense counsel on the other side, you may think you've got it covered, but like you said, witnesses change their stories. Sometimes they don't show up at all. I've had situations where you talk to them the day before and then you show up and it's like, where are they? Or they're late. And the court's, pushing to go forward. So it's not always the most comfortable position. So just keep in mind that if we are advocating to compromise, it's not because we don't believe in our case, but it's because we think all things considered, it's the best outcome. So, all right. Question 2. That's also another good question. What do you need an expert at all? What's the value of having an expert for trial? Let's start with Mike on this one and hear what his thoughts are.
Well, generally, witnesses are only allowed to testify as to their personal knowledge. And sometimes you do need an expert. An expert is allowed to offer opinions based on facts or data and evidence that the expert has become aware of or that the expert's personally observed. So sometimes you need an expert to establish things such as the value of damages. Sometimes you need an expert reconstructionist, for example, in an auto accident case to establish liability. Sometimes you need an expert, you always need an expert for the most part in a product case or a construction case, and definitely in a fire case. So what happens is there's the easy case where you have an expert retained probably for the investigation portion pre-suit, and there's no question that that's an expert. What happens is it gets really fuzzy when you're talking about maybe qualifying an adjuster, an appraiser as an expert, or somebody who worked on the claims process. When you're working on a coverage suit or a bad faith suit, then it gets really fuzzy as to who's an expert and who's not an expert. But I think for the most part, you always need fact witnesses with personal knowledge, and that's usually the insured. That's sometimes the adjuster who handled the file. On complicated cases, you almost always need the pure expert to come in and render an opinion, more likely than not, based on skill, education, training, and experience. Whatever it is, the value, they did something wrong or the value of damages. And then usually what I try to do is I usually try to qualify the adjusters as quasi-experts to render opinions, just in case we need to establish some other issue of liability or damages, just sort of to dot the I's and cross the T's.
Tiffany or Nate, anything else you want to add to that?
I'll just piggyback on what Mike indicated. When you're talking about causation, most likely you're going to need an expert. So you want to take a look at whether the person who is going to testify, if they're testifying, like as Mike said, as adjusters, they may be qualified as an expert, or are they going to have to make a leap of conclusion regarding causation or whatever the case may be. If there's going to be a little bit of a leap, then you probably need an expert to explain that to the jury. And so that's the way I kind of look at it, whether there is a blank space between what we believe and what we want the jury to believe. And if there's some kind of void there, you're probably going to need an expert to come in and say, this is how, from this default issue or faulty equipment to this particular loss, that's how that occurred. You need someone to bridge the gap between whatever your loss is and that damage from that loss.
I should probably add that in bodily injury claims, at least every state that we're involved in, expert testimony is required to establish the reasonableness and the relatedness of the treatments to the injury. And, the only time that you're going to get away with sort of presenting evidence of med pay or reparations benefits or a bodily injury settlement is when the injuries are so obvious to a layperson that you don't need expert testimony to connect them up to the injury. And that usually means a broken bone. And even then, if there's defense counsel on the other side, they're going to challenge that and say, well, the treatment wasn't really necessary and reasonable. So really in any case where you've got significant medical injuries or medical claim, you're going to need an expert if you want to pursue that to trial.
Yeah, you're going to need a doctor, and they're expensive, and it's you know, if you're talking about an uninsured motorist, sometimes, you know, I think it may be advantageous just to drop that portion of the claim if you've got a significant property damage claim that you can take a judgment on. So you're at least collecting on something, but that's always something to weigh, you know, going to trial. Is it worth it to spend an extra, you know, $5,000 or, you know, if it's even more to get a medical expert to testify at trial against an uninsured motorist? You know, 99.9% of the time, I would say it's probably not. But that's something to weigh when you're in those situations.
And just something to add on to that, even when you try to utilize the treating physician as an expert, it's still costly. So, you know, you may be able to cut a little bit of cost because they've already, you know, for the most part, reviewed, you know, medical records, they've already seen the patient, but there's still a lot of costs associated with that as well.
What is the difference between a judge and a jury at trial? Who wants to take this one first? Any volunteers? We'll go to Tiffani. She looks like she wants to talk.
Jump in. So it depends on what type of trial we're talking about. So there's two types of trials. You can have what's called a bench trial or a jury trial. Bench trial is when the judge is actually the person who decides the law and decides the facts of the case. Or you can have a jury trial where the judge still decides the law, but the jury will decide the facts of the case. So when you have a jury trial, let's start there. There's a world of differences. So when you have a jury trial, typically, you know, jury, you know, they are comprised of people, obviously. They're lay people for the most part. And usually attorneys, we'd like to kick attorneys off, although I have sat through one trial as a jury member. I'm not sure why they allowed me to be on there, but they did nonetheless. But usually you do not want attorneys on there, as they will hijack your jury. But when you have lay people, sometimes things that are not legally relevant to the case can seep into the minds of the juror, even though they're instructed not to do so. So, you know, I referenced earlier, you may have the insurance company on one side and what appears to be a layperson on the other side. Well, you know, they may see the insurance company as a big pocket and the layperson as a smaller pocket. And so they may want to side with the layperson. But that has nothing to do with the merits of the case, but that's just human nature. Typically, jury trials are going to be more formal. So you have, you know, your court rules for whatever particular state you're in that the trial is being conducted in. And so usually, you know, the witnesses, you're going to want to make sure you have all of your facts elicited from the witnesses. You're going to have all of your witnesses present and able to testify. And it's more of you're putting on a show, you're painting a picture, because in the world of CSI, jury members like a complete inaccurate picture of what's going on. They don't want any blanks, they don't want any confusions, they want it laid out for them. A judge is not going to be as formal. So if you have a bench trial or a trial by a judge, it's not going to be as formal. One, because the judge knows, you know, the laws already. He doesn't need the procedural mechanisms for sometimes laying a long foundation for a particular record, you know, or he doesn't need complete testimony regarding the damages to the vehicle. He may just want to just look at the estimate, or she may want to look at the estimate or look at the photographs. So sometimes with the bench trial, it kind of short circuits some of the things that you need to prove and to show, because the judge wants to get to the point, wants to get it done, wants to get it over as quick as possible. And jury trials are costly and they're a lot of work. So you have to pick your jury. You have to, you know, make sure that those people are individuals that can see both sides of the coin, and that will give you their full attention throughout the entire case. So it's a long process when you have a jury trial.
You know, we have a lot of the same considerations depending on the court that you're in. So, you know, if a claim's in small claims court, there are no rules of evidence and pretty much anything goes. But, you know, we've got small dollar courts and large dollar courts, and then there's federal court. And, you know, the larger dollar courts or federal court requires you to really prepare. And you got to have your documents lined up and marked and presented in a certain way. And you've got to have your witnesses lined up and identified and presented in a certain way. And, you know, there are a lot of considerations depending on, you know, what court you're in, what judge you're in, and whether you're going to present your case to the judge or to a jury.
And to kind of piggyback off of what Tiffany was saying, I think from a witness's perspective, the phrase that Tiffany used, you know, it's more of a show when you're talking to a jury. From a witness's perspective, the bench trials are far easier because I got to look at one person. That person knows the law of what we're talking about, knows these cases, has probably tried 400 cases exactly like the one we're talking about. And as a witness, I only have to make that connection to one person and convince one person that I know what I'm talking about. With a jury, you know, you've got 6 or 12 or however many, you know, depending on your state, people that probably know nothing about a debt collection or a subrogation or whatever case we're talking about, probably know nothing about the law, you know, the black letter law, the case law that we're actually talking about. And convincing that, you know, that panel or that group of people that I know what I'm talking about is a very, very different story. And it's a very different process because, you know, when I'm talking to a judge, you know, I can, as a witness, if I've prepared myself correctly, I can use certain words and phrases that the judge immediately clues in and goes, okay, I know what this guy's saying. I know that this guy, or, you know, whoever's on the stand, I'm talking about myself, know that this guy has prepared himself, knows the facts, and knows what he has to do to get those documents or get those facts or whatever the situation is into the record, and is doing that. This person on the stand knows this business, knows what they're talking about. But again, you know, convincing a panel of 6 or 12 people that I know what I'm talking about is a very, very different story when they're not a judge and they don't know, you know, the legal background and the legal elements of certain cases. So it's a completely different preparation.
Yeah, and I don't know if any of you have sat on a jury. I have, and it's very eye-opening because, you know, I might have one perception of a witness, and I might be the only one who saw it that way. And I was like, wow, you know, it makes you really realize how different people take different media. Well, think about our daily lives. Like, how many people will watch a movie and take something completely different than what you did? So that's something to consider when going into a jury trial. They're much more performative. It's much more production. And yeah, it's almost like a play. It's almost like we're putting on a play saying, this is how it happened. And the other side's going to like, no, it actually happened a little bit different. It happened like this. So definitely a big difference between the two. I typically steer clear of juries as much as I can, unless a particular case for a reason gives me, you know, a reason to want to do it. Also, particularly in, like, if we're talking in like an uninsured motorist context, very rarely will you see a defendant request a jury because it requires a deposit, and as Tiffany said, they are more expensive and you know, more work. So we don't get them that often, but when you do, you need to realize it's a whole different ballgame. So, all right, I think we can move on to the next question. We're looking at the different phases of a lawsuit. You know, what all is involved in a lawsuit, and you know, what preparation before you get to a trial stage. What will you need to be prepared for as a client? Anyone want to jump in on that? Tiffany, you're smiling. You gotcha. I gotcha.
Right, I was supposed to stop making eye contact with you at that point, right? So.
Well, if I look weird, it's because my monitor's on one angle and my cameras are right in front of me, so I'm like kind of giving you the side eye, but not. I don't intend anything by that.
So the lawsuit or the litigation actually starts at the moment of the loss. So, in our last Ask a Pro series, we talked about preserving evidence, sending letters to opposing side, giving them opportunity to inspect evidence, things like that, especially if it's dealing with items that potentially may be destroyed. So it starts actually right at the time of the loss or shortly thereafter the loss. You're thinking about potentially this could go down the road of litigation. So if you have that mindset and you can get your subrogation department in early, or if you're in a subrogation department, plead to your claims department to allow you to get in a little bit earlier, that would be beneficial. So once you have identified who the entity is that you want to be responsible, so whether it's an uninsured motorist or it's a company that sold a defective part or whatever the case may be, you want to start working on your elements. Start talking about, do we have causation? Do we have proof of our damages? Do we have things to support what we say? And the best way to do that is just ask yourself, okay, what do I need to show somebody else? What do I need to explain to a trainee that, here are the damages. Here's how I know this person is at fault. Here's how I know it's that person. It should be that particular person. And if you're explaining that to the trainee, then go through what documents you would pull. And if you find yourself unable to locate a document to show one of those things, for example, how do you know the person was what steps did you take? Then you need to try to build that portion of it up. So the first step really, once the subrogation unit gets involved, is building up your docs. Then obviously you want to work with your attorney regarding seeing if you can resolve this outside of court, because obviously resolution outside of court is more cost effective than going through court. But let's say you can't do that and you have to file suit, which we file suit all the time here, obviously. So once you file suit, you have your initial complaint that spells out exactly what you're asking for, who you want to sue, and why you want to sue them. So it tells everybody in the world who reads that complaint why we're here. Okay, and it puts the defendant on notice. Then the defendant has the opportunity to respond in some way, answer it, maybe file a motion saying, no, there's nothing to see here, judge, let's just dismiss this case. Once you get beyond that point, you're in active litigation, and that's where things get interesting. So in Michigan, at least, we have a period that's called a discovery period. And so you, as a claims professional, may not necessarily know that the case is in that stage of litigation, but for the fact that we may bug you a little bit more. So we may say, hey, I got these questions. I need you to take a look at them. I need you to answer them. I need you to sign them. Oh, but I don't have this particular document. Can you get this document? They're requesting it. So we may bug you a little bit more about additional things. But discovery basically is an opportunity to exchange information between the parties, because at trial, things are not like they are on TV where, old school reference, Perry Mason would come in with the surprise witness and just win the day, or this one piece of evidence to just, takes everybody by surprise. No, you already know that before you went to trial. You know that witness is going to be present. That was disclosed to you before trial, and that document was disclosed to you, or you won't be able to use it at trial. So you have your discovery phase. Now, cases typically can go a lot of different ways. In Michigan, at least, the courts really push what's called alternative dispute resolution. So they're trying to settle the case without going to trial, because less than 1% of cases actually go to trial. So judges do not want the cases to go to trial. Litigants, if they knew the trial, they wouldn't want it to go to trial. And also the attorneys want to avoid trial if it's, not in the client's best interest. So most of the time, resolving the case with a mutual agreement will keep everybody unhappy to some extent, but everybody happy as well, because you have at least a number that everybody can agree to, versus a number being forced upon you by the judge or the jury. And after you get through your alternative dispute resolution and then you're not able to settle the case, then that's when you get in the phase of building the case up. So you need to, whether you need to do some sort of deposition or video deposition or getting additional documents, whatever the case may be, you go into building your case, painting your picture, assembling your things for trial. And it's going to depend upon whether you have a jury trial or a bench trial and how soon you have to do that. For a jury trial, it's usually 60, 90 days before the trial, because you have to pick your jury, you have to do your voir dire questions, a lot of work that goes into that. Instructions to the jury, you have to decide with the other side. With a bench trial, you may be able to push that a little bit closer to the actual trial date.
So we have our pleading phase that you talked about. You've got your discovery phase, your motion practice phase, your alternative dispute resolution or mediation phase, and ultimately, if it can't be resolved, your trial phase. I want to sort of focus on discovery for a second because I think it's very important, and we need our clients' cooperation very much during that part of the case. And I would like to take this opportunity to press upon our clients, or that now's the time to sort of put up or shut up, right? If we have evidence, this is the time it needs to be produced. I don't know if any of you have had the nightmare where only when you're about to go to trial, there's an additional piece of evidence that all of a sudden someone has made the effort to obtain that you didn't know about. And that's a nightmare, because really the sooner you have that, the better you can resolve the case. But yeah, there's a whole list of ethical issues that are raised by bringing it up at the wrong period of time. Does anybody else have anything to add in that regard, or anybody faced anything like that in the past about discovery?
Yeah, I've definitely run into an issue. It was actually on a foreclosure case, but a piece of evidence or a recorded document came up at the last minute, and it was one of the worst nightmares of my professional career. So, anything that the clients, any information that's available, any documentation that's available, good or bad, we need to know about it immediately. If it's good, then we can use that documentation or that evidence to our favor. If it's bad, we got to prepare for it and figure out what we're going to do about it. So the sooner we know about it, the sooner we can, figure out how to use it or how to, do damage control depending on the situation. But having something pop up, Tiffani made reference to that Perry Mason moment, and while it's not supposed to happen, I've had it happen at trial where somebody is waving a recorded document in the judge's face, and it's real hard to argue that it doesn't exist or that it shouldn't be brought into evidence when it's a recorded document. It was something that does in fact exist. It's very hard to get around that, and obviously with subrogation, the recorded document is probably not going to be a situation that's going to come up, but still, judges and or juries can take these things into consideration, whether or not they're supposed to, or whether or not we've played by the quote unquote played by the rules in bringing it up. But it's a dangerous situation to have surprise witnesses or surprise evidence slap you in the face the day before trial or at trial.
Yeah, if no one else has to add, move on. Want to add something?
No, I agree. In Michigan, we may be a little bit stricter in that we, once you disclose who your witnesses are, then that's it. Once you disclose your exhibits, that's pretty much it. But I think Nathan raises a great point in that tell us the good and the bad. So just because you have a document that you believe that is not favorable, you should still share it with us as well, because that may be something that, one, it may not be as bad as you think that it is, and two, we can prepare for it.
Yeah, that kind of all rolls into the next issue, which is the role of a witness in a subrogation case. And if I'm going to call on you in a second, but maybe we can address, not just at trial, but at deposition. or maybe it's just a damages hearing. But if maybe Mike, if you want to take a stab at what the proper role of a witness is, and we'll want to hear Nathan's comments too, as someone who's been a witness.
So I guess to go back for just a second to the life of a litigation case, when we get a trial notice or a deposition notice, I usually like to try to secure the witness, or at least identify the proper witness as soon as possible. And the deposition or trial might not be for a few months out, or maybe even 6 months out. And then after we schedule an initial appointment, we go through sort of what the topics are that witness will cover. That witness can sort of disappear until maybe a week before trial. And then I really sit down with the witness and we go through everything and we practice questions and answers. But a corporate witness, it's sort of unusual in that, again, most witnesses usually testify from personal knowledge because they were there, or you have experts who can render opinions based on skill and experience, from facts and evidence. But corporations aren't people, so they don't really speak. They speak through their documents. So the corporate witness is sort of challenged with the obligation to answer on behalf of the company. So that witness needs to prepare a little extra carefully so that they're not rendering personal opinions, but speaking on behalf of the company based on their acquiring information and reviewing documents. So I guess and the context of what they're required to do will depend on the type of the case. So I guess primarily in a subrogation case, you've got to worry about maybe coverage, the right of subrogation, the insurance policy. You're going to talk about maybe basically the claims process. And then that witness is going to be responsible for identifying documents. And that may be liability documents, that may be damages documents, and that certainly will be payment documents. And at the end of the case, at a bare minimum, they're required to say, this is the amount that we're entitled to recover. I hope that was responsive.
Yeah, I think it was. Go ahead.
Sorry, Ted. Yeah, just to kind of piggyback off of that, I'd mentioned that I was a corporate witness for a debt buyer, so slightly different than the subrogation case, but to the extent that Mike mentioned that the role of the witness is to bring in the documents, that's exactly what I was doing in that prior role. So yeah, the preparation is very different than if I was testifying about, oh, this is what I saw at the scene of an accident, or this is what I saw at the scene of a crime, for example. Just to kind of bring it to something that people might have seen on TV. It's not like that. It's not like, oh, this is what I saw, this is what happened. But it's more of this is what this document is, this is what this document says, this is how this document was prepared, this is why I can testify about what this document says, this is why the company that I work for created this is why this document is a record and can be relied on. So that's really the crux of what a corporate witness, or a witness on behalf of a corporation or a company is doing, is saying, this is the document, we can rely on this, we have the right to rely on this document, it is what it is. It's a very different process than, like I said, if you're doing an eyewitness testimony. It's more of I need to convince the judge or the jury that I know what I'm talking about. I've been with this company for X number of years. I have this amount of experience reviewing these documents. These are the documents that I look at for 8 hours a day, 5 days a week. I can tell you what this document is. So, a corporate witness, even in a subrogation case, different than a collection case, that's still your primary responsibility, is to say, this is what this document is, this is what the document says, this is why I am a reliable witness and I can testify about what this document says. This document says that, John Doe owes this amount of money, and whether we're talking about a subrogation or a collection case, that final conclusion is really the same. This is what the documents say, this is why John Doe owes company X this amount of money. So while it's a different preparation process, collection versus subrogation, that's still the primary role of the witness.
Yeah, and I think it's also sort of important to remember, like we mentioned earlier, like the insured or the driver needs to show up, and you may need them to prove your liability case, because without them, you may be able to prove all the damages, you may be able to prove your subrogation payment and get your records in, but without the underlying proof of negligence in a simple car accident case, you know, you're going to be lost. So, and whether the witness is an insured, a guest passenger, an independent observer, those are all other kinds of witnesses, you know, separate from the corporate witness that we're going to talk about mostly. But yeah, they all play different roles. And in the deposition, you're going to need, it may be the same witness you have a trial, it may not be. So those are all things to consider. All right, move along. So how would a claims adjuster best prepare for giving testimony, either be at a deposition or a trial? Tiffani, you were an adjuster, so you might have some knowledge or experience in this realm. So if you could share with us your thoughts.
Yeah, so you want to start with obviously reviewing the claims file, reviewing the claims notes, especially if you're acting as a custodian of records or a corporate witness. You may be testifying to things that you, a file that you didn't adjust. And usually as a subrogation professional, usually you did not adjust that file. So you may have had little contact with actual claims handling. So you want to make sure you review the claims file, review the documents, review the notes, pay close attention to the notes that are related to, you know, your particular aspect. So if it's a subrogation claim and it involves, you know, personal injuries, obviously you want to know what the injuries are generally, you want to know the course of treatment, things like that. As far as testifying itself, whether it's at a deposition, a hearing, a trial, you just want to keep in mind a few things. The first thing is try to, as much possible, stay calm. Now, some attorneys will try to ruffle your feathers to get you upset. And the reason they're doing that when they're questioning you is because they want you to get off center. They want you to maybe say more than you would normally say, come off as combative, forget things that you would have testified to. It just throws you off your game. It's a strategy, so you want to try to minimize that. And the way that you minimize that is listen to the question, absorb it, and then provide your answer after a few seconds. In a deposition, you have to remember there's only you and the other attorney and the court reporter. So if you take a few seconds to answer, it doesn't come on the transcript as if you took that time to you know, think about your answer. Obviously, at a jury trial, you don't want to be sitting there for 5 minutes thinking about your answer. That probably would not go over well. But you should, you know, reflect for a second. You should make sure before you start speaking that you completely understood the question in its entirety and you know what your answer is going to be. And your answer should be just responsive of that question. In normal conversation, we know exactly where somebody else is going. And so we may add additional information, but that question didn't call for that. So when you do that, it puts your attorney at a disadvantage, because if the attorney knows the file and they pose a question or the other side poses a question or the judge poses a question to you, the attorney knows what your answer is going to be. If you volunteer information, they have no idea what you were going to say. And that information that you volunteer may in fact be something that was not admissible. There may be a reason why that question that was posed to you in a particular way to not elicit that additional information. So just answer the question that was posed to you. When I'm actually deposing a witness, I usually use a more of a friendlier approach, because I want the person to just tell me all the information that maybe their attorney didn't want them to tell me. So that's usually the approach that I use. But you just want to make sure you're answering just that question that was posed to you and not volunteering additional information. And I alluded to this before, when you answer a question, it's always presumed that you heard the question, you understood the question, and you're answering truthfully. So the moment you start speaking, that's always presumed. So if any of those three things do not line up, you need to make sure you ask questions and say, oh, I didn't hear that question. Can you repeat it? Can you rephrase it? You as a witness can do that, because in order for you to testify truthfully, you have to have first understood the question that was posed to you. And then finally, when you're answering a question, do not guess, and it's easy to, review the claims file and you're like, oh, I think the injuries were to the back. I have so many files where there's still a neck and a back, so it probably was. No, don't guess. If you need to look at your claims documents or your notes, there's a way that we can get those in to have you, in essence, refresh your memory to be able to testify based on the actual hard copy documents regarding something you may not recall. But just don't guess at an answer.
And if I can add just a little bit, as someone, as I mentioned, I've been on the stand multiple times, I've been deposed multiple times. One of the things that I wish someone had warned me a little ahead of time is exactly what Tiffani was talking about. There are some attorneys out there that really use as a strategy and really, it seems, enjoy trying to get a rise out of the witness. So, and this seems to happen, at least in my experience, particularly in depositions, where the opposing counsel will be extremely combative. I've had people flat out insult me to my face at depositions, trying to get that reaction out of me, trying to throw me off my game and trying to get me to say things that I don't mean, or to phrase things in a way I don't mean. It's happened on the stand a couple of times where, they'll try to get me into a state of being combative with them and arguing with them in front of the judge, trying to make me look bad. So, I'm not going to say that every witness is going to have that experience every time, but it's certainly something to be prepared for. And then I'm going to contradict Tiffani just a tiny bit when she was talking about a witness, only answer the question presented. I think that's 100% true in a deposition or when opposing counsel is questioning you. In my experience on a bench trial, if the witness is comfortable and has done multiple trials and is really knows what they're doing on the stand, I've had situations where, for example, an attorney has asked, asked me, who I am, who I work for, how long I worked for them, what my role in the company is, and then said the question, Mr. Duvelius, why are we here today? And I just went. I rolled through the case. I told him why we were there, what happened, what the documents are, how much this person owed, and why we should get judgment. So, while it's probably a good idea when there's opposing counsel asking you questions, to only answer the question presented, when it's a bench trial and it's just your attorney and then maybe one person or a pro se defendant, sometimes if the situation calls for it, the longer you can talk, the more it sounds like you know what you're doing. So, in those situations, and that's probably something that you need to talk to the attorney who's representing you, representing the company ahead of time, so that both of you are prepared for that. If it's your first trial and the attorney asks you, why are we here today? And you go, because they told me to, you don't want that. But if it's something you're comfortable with, the longer you can talk, the more you can roll through the documents and do that yourself, particularly in a bench trial setting. I think it really helps the witness's credibility.
Yeah, excellent point about the difference between direct testimony and cross testimony, right? I'll tell you, I've learned as much or more from some of the professional witnesses I've dealt with over the years than from other attorneys as far as trial, because we're not infallible as lawyers, right? And we don't always, maybe sometimes we forget to ask a pertinent question. And if you have an experienced witness who knows how to steer the conversation, it can be very helpful.
Yeah, witnesses are always incredibly nervous, and giving testimony, whether at a deposition or a trial, is a nerve-wracking experience. Everybody's uncomfortable and everybody's very, very nervous because the stakes are high and you want to do a good job. And the paradox there is that the witness who's very comfortable and very direct and straightforward is more credible. So the witness who's confident and calm and direct and sincere and serious is the more believable witness. So from the witness perspective, my job as the attorney is to make that witness very comfortable. So, we we practice questions and answers. I give them questions in advance, and we go through all the crazy rules, and we ask those questions. You know, the question, do you know what time it is? The answer is yes or no. We don't want the witness sometimes saying, you know, giving us the time. So there's just really no substitute for practice. And that's our job.
What documents from a claims file are admissible at trial? Tiffany, let's start off with you again on this.
I didn't smile this time. Ted, what are you talking about?
I'm picking at you.
I will be brief as possible. So most documents can be admissible at trial that are created and generated by the actual insurance company. At least in Michigan, police reports are not admissible at the point of trial, with the exception of maybe the actual identifying information could be used, but the narrative is not admissible, so we cannot use a police report as a substitution for determining who's at fault for the accident. So in Michigan, police report case law says no. For the most part, again, just some of the actual identifying information, but the narrative usually is not gonna survive an objection. Now, with that being said, if you have a bench trial and you'd have an improper, you may be able to get that police report in sometimes. They don't know to object. But if you have an attorney on the other side, for the most part, that's not going to be admissible. But your estimate of damages, usually that's going to be admissible. You'll be able to get that in through, at least in Michigan, as a business record, your payment logs, same thing, a business record. So those documents that you create most likely are going to be admissible. The things that are going to the truth of the matter that's, you know, outside of documents that you actually created is not going to be admissible.
Yeah, as a corporate witness, I think Tiffani, you know, kind of hit the nail on the head. As a corporate witness, it's the business records that the corporate witness is really presenting. And you know, there are some extra exceptions and extra weirdness when you're talking about you know, a collection file where you're a debt buyer, and you know, we won't go down that road on this webinar. But you know, as the corporate witness for the insurance company, for example, yeah, it's the business records. It's anything that your company created in the course, normal and ordinary course of their business. You as a witness are going to be able to introduce that as evidence. On the police report, because it's an outside source, it's a little different, and there's some, you know, ifs, ands, and buts there. But you know, the short answer is anything your business created, you can most likely be able to bring that in at trial.
Yeah, coverage and bad faith claims are significantly different than the typical subrogation claim. You know, so the notice of loss and the notes, its work product, the investigative stuff, that's usually not going to be used at trial, and it's not going to be discoverable. I think the key thing is we need to use the insurance policy, the deck page, the invoices, the estimates, the appraisals, the loss information, the damages information, and the payment copies. Where it gets a little weird is when you're trying to prove liability. You know, frequently we'll have a police report that will put 100% fault on one party and 0% on the insured. And it may be, you know, you've got different people who say, I had the red light, I had the green light. But when you boil it down for trial and that police report doesn't come in, you've got to prove it. You've got to prove it all over again. So the police officer may not be competent to testify if the police officer wasn't there to actually witness the accident. So then it really becomes a word versus word accident. And then, you know, even though it's 100% on the police report, you're at a 50-50 type word versus word claim at trial. And that really changes the dynamic of whether you should even go forward to trial or not.
I'm going to make one more point briefly because we have about 5 minutes left in the session, a couple slides to get through. But Nathan was bringing up the debt buyer. There is an analogy to the subro case, though, and the adopted business records, because oftentimes the repair estimate is not generated necessarily by the carrier. It's generated by a repair shop, but it is a record that the carrier relies on in the ordinary course of their business. So at least in Ohio, there's an adopted business records exception that will allow that to get in as a record of the carrier. So we've touched on this a little bit, but helpful tips for testifying at hearing, deposition, or trial. Start with Nathan, since you've got the most experience there.
Yeah, I think we've kind of already addressed the biggest ones, and they are, be prepared that a opposing counsel may try to get a rise out of you, may try to throw you off your game. And again, something else that Tiffani mentioned, think about the question, take a beat, take a pause, so you can gather your thoughts. Now, sitting there for a full 10 seconds and going, before you answer at a jury trial may not be the best answer, may not be the best strategy, but even then, taking that moment to kind of, pause, think about your answer and go, okay. Also clarifying the question. There's nothing wrong as a witness with saying, can you repeat the question? I didn't understand. Can you rephrase that? I think you're asking about this. Can you clarify? Because the last thing you want to do as a witness is start talking and answering a question that wasn't the question that was asked, or to answer it completely wrong because you misunderstood what they were trying to get at. So, and even when your own attorney, when your own counsel is asking you, clarifying the question, there's nothing wrong with that. There's nothing wrong with saying, I don't know what you're saying. I don't understand the question. Now, if it's a, hey, what time is, or do you know what time it is? And you're saying, I don't understand the question, we got a problem. But, clarifying and making sure everybody's on the same page is not a bad thing. And the other thing, one other kind of helpful tip to bring up is at bench trial, the witness should be prepared that the judge very well can and probably will start asking them questions. The first time that I was on the stand, the judge started asking me questions. My eyes got real big. I was deer in headlights because I wasn't expecting that. But it does happen, particularly if the defendant is pro se and pro per, depending on which state we're in. The judge may. I hate to accuse a judge of advocating for the defendant, but sometimes all the attorneys on this screen are nodding at me that that does kind of happen sometimes. So the judge may ask the witness some tough questions and some pointed questions. So the witness needs to be prepared for that and prepared to answer those tough questions coming from the judge, which is very intimidating. Particularly the first time they experience that. So, just a couple things to keep in mind.
I'll jump in just really quickly. So I just want to just kind of reiterate something that Nathan said that actually is really good when you're testifying at trial with a jury versus the bench, making eye contact with those jury members. So the way that you present and the words that you choose, remember they're lay people, and so try to make it more conversational versus if it's a judge, you can be a little bit more technical. So I thought that was a really great point that Nathan made that I just wanted to circle back on under that question.
What about the difference between testifying virtually versus in person? Anybody want to tackle that real quick?
I'll tackle that because I've done some trials by phone. This was in the days before Zoom was really popular, pre-COVID. To me, testifying by phone is a very different experience than testifying in person. There were a couple of states that would allow that. That being said, testifying or even being an attorney on the other side of the bench or on the other side of the witness box rather, I don't find that to be all that different in person versus virtual, at least in the context of a bench trial. I don't know how well that would play for a jury trial, though I doubt a virtual jury trial is going to happen all that often. But I think particularly in the post-COVID world, judges and attorneys are so used to doing things by Zoom, webinars such as this, that I don't think there's that big of a difference when we're talking about testifying. But I don't know if anyone else has a different experience.
So there's a big push lately to testify by video conference, and the federal rules at least permit it because the subpoena power of the courts generally only extend to the state borders and maybe in federal court 100 miles past the state borders or from the courthouse. The problem is that almost no judge wants to have somebody appear by Zoom. They would rather have somebody appear live and in person. So usually if there's, at least for secondary witnesses, somebody who's maybe not critical to the elements of the case, the judge may allow remote video conference testimony. But for the key players with regard to liability and damages, the judges pretty much always want those people present in the courtroom for cross-examination. And there's really, in my mind, there's no better way to convey a message with credibility and sincerity than to be there live and in person. You just don't get the same feeling from watching somebody on video. And having experienced, video depositions in front of the jury, the jurors almost always fall asleep. Even no matter how compelling that testimony is, they're just really not into it, and they just really don't pay attention. There's really no substitute for having somebody live if that's a key witness for your case.
Yeah. Well, so it looks like we're in the end of our hour here. Like I said, you'll be receiving a survey, so please take your time to review that. But otherwise, thank you so much for joining us today. And if you have any questions, you know how to get a hold of us. And we'll look forward to seeing you next time. Thank you.
And if there were any questions that were submitted that we didn't get to, we will send out we'll send out the answers to you as well.
Yeah. Thank you.